All right, good afternoon, everyone. We're back on the docket for the afternoon. And for those of you, this is first appearance court. Today we'll talk about whether I find probable cause to detain you, and then we'll talk about release conditions. Please do not talk about your case when you come up, because everything in this courtroom is being recorded and can be used against you at a later time. I say it every day, but someone always says, I'm not talking about my case, but then proceeds to talk about their case. So please make sure you speak with your attorney before you say anything today. There is one that was reset from the morning, and so we can call that one first. Is two? Hold. All right, so we'll call those two first. So John Ingram, we have.
How are you, Judge?
How are you?
Nathan Evans on his behalf.
What was your name, sir?
Nathan Nevins.
Mr. Nevins, good afternoon. All right, Mr. Ingram, you are before the court for count one is domestic battery by strangulation, and count two is touch or strike battery. And I do find probable cause, and I'll hear from your attorney as to bond.
Judge, I just want to take a little testimony about his job and his.
Okay.
Can you hear me, John?
You have to turn on your microphone, Mr. Ingram. Is someone at the main jail? Thank you.
Yeah, I can.
Where do you work, John?
I do the maintenance for the racetrack.
Could you describe what that means? Is it just one racetrack, or?
No, I do it from Hollywood Boulevard all the way up to Blue Heron. Every racetrack store in between Hollywood Boulevard and Blue Heron.
So how does that work in terms of which one you go to?
We got a cycle, like 2 cycles. So 1 week we do the first cycle, and the next week we do the second cycle. And we do 2 stores a night. And it's 8 to 4, 8 p.m. to 4 in the morning.
How long ahead of time do you know exactly which store you're going to go to?
I got a schedule, so I know before I get to work.
So like about one day, you mean?
Yeah.
Okay.
You can say that.
What kind of family members do you have in South Florida?
My mom, a few aunts, cousins, brother, one brother stay down.
Have you ever lived outside of the state of Florida?
Yeah, I stayed in Atlanta and California.
How long ago was that?
I stayed in California for a year. That was like right after I graduated high school, and I stayed in Atlanta for like 5 years.
How long have you lived in South Florida?
Probably about the last 10 years straight.
And how many years total?
I give or take, probably like 10 to 15.
And do you have a passport?
No, I don't have a passport.
So you've never left the country, obviously?
Nah, Puerto Rico, but you know that's part of the United States now. So.
Sure. Judge, I don't have any other testimony at this time. We'd ask for... actually, sorry, I have one other question. Can you afford bond right now?
It depends. It depends, but I think I can get a bond if I need to. If I was issue one, I think I can get it.
So, Judge, we'd ask for a reasonable bond. In this case, he has significant ties to the community. He has a great job. He does maintenance for, racetrack, not just one store, but basically what he's describing is multiple counties. He is responsible for the maintenance in many different racetracks. So we'd ask for a reasonable bond in this case.
Okay, Steve.
Your Honor, I'm going to be requesting a $15,000 bond, pretrial release with a GPS monitor, no victim contact. I'm concerned based on the allegation that he strangled the victim to the point that she was unconscious. I would also note what I consider to be an aggravating factor, her medical condition, which it would appear Mr. Ingram was aware of, that she is asthmatic.
Judge, I just want to very briefly respond. Just look at
I wasn't done yet.
Sorry about that.
Would also note Mr. Ingram is out right now on a pending felony possession of THC that's in drug court before Judge Porth.
Just want to point out, Judge, that were you finished?
Yeah, go ahead.
Okay. So just want to point out that was PTI drug court. That's PTI drug court judge. He was considered low, the very minimal risk. It was a vape pen, which is why he was in drug court. He's complied with everything. No positive drug tests. And, we're not arguing PC, but I do want to just note the very last line of the PC that it should be noted that the only visible injury to the victim was a minor abrasion on the left wrist. So I think that is a mitigator. So we'd obviously ask that you don't revoke his bond. This is a case that, assuming that he would have done drug court successfully, it actually would have been dropped. So, and the fact that he's in PTI drug court shows that his criminal history is basically non-existent. So we'd ask for a reasonable bond. And if you are going to impose some sort of pretrial release, we'd ask you to consider the fact that for his employment, he can't really set like a week-long schedule. He only knows about a day ahead of time which store he's going to be at. So we'd ask for a standard pretrial if you are going to set that.
All right, thank you, everyone. I do find probable cause, and based on the allegations that are before me, and that's what I have to make a decision based on.
I can't say no until they say something.
It appears that this is, as a result, some argument ensued as a result of a breakup, and that the alleged victim's neck was squeezed to the point where she passed out. So based on those allegations, I do find probable cause. I am going to impose a bond of $10,000 with a level 2 GPS. He'll still be able to go to work.
And Your Honor, I just hadn't
No
thought about it.
victim contact.
There's a bond needs to be set on count 2. Whatever the court, in your discretion, believes is appropriate, I'm fine with.
I'll impose a bond of $1,000 on count 1, on 2.
Do you have any children?
All right. There was Paul Leaf. Paul Leaf was reset from this. Okay. All right, Mr. Leaf is before the court. 1 count of aggravated battery with a deadly weapon. Counts 2, 3, 4, and 5 are battery on an officer. Count 5 is possession of MDMA. Count 6 is Count 7 and 8 are resisting officer. All right, let's do it again. Count 7 is resisting officer with violence. Count 8 is resisting without violence. Count 9, 10, 11, obstructing or depriving means of protection or communication. Count 12 is tampering with or fabricating physical evidence. And count 13, obstruction or depriving means of protection or communication. I'm sorry? I have 2 sheets here. I don't have a 14.
Yeah, that's what he was reset for this afternoon. They added a parole hold, Your Honor. I don't know if you have the findings for it, but
I don't have it.
maybe it's in the...
You mean in the regular packet? All right, so we can throw this one out then.
One is 1 through 13, the other one is just 14.
No, this has everything on it. Okay. 14 is a parole violation. All right, I'll give it to you. You can. All right, I do find probable cause, and I'll hear from the parties as to bond.
I seem to remember from this morning, and unfortunately I did not pull Mr. Leith's paperwork from this morning, but I remember asking myself after reading the probable cause affidavit what the deadly weapon was as relates to count 1.
His handcuff.
Okay. That's what I had thought, but I remembered I had a question about that.
They didn't put the PC on this one. So we'll just staple it all together. Okay. All right, state.
Thank you, Your Honor. I'm going to be requesting a $20,000 bond on 1, $2,500 bond on 2, 3, 4, and 5, $1,000 on 7, $10,000 on 9 and 10, $2,500 on 11, $2,500 on 13. Your Honor, first I would note Mr. Leith's criminal history. He's on parole for battery on a law enforcement officer. In 2016, he was convicted of battery on a law enforcement officer and sentenced to 40 months in state prison as a habitual offender. Now, I'll leave out other priors, but in 2005, battery on a law enforcement officer, resisting with violence, attempting to deprive an officer of a weapon or communications device, and injuring a police dog, 5 years state prison. 2005, battery on a law enforcement officer and resisting with violence, 5 years state prison. 1996, battery on a law enforcement officer. He's also had multiple drug priors, grand theft auto. He's gone to prison on those matters. I'm concerned about the allegations. In this case, most notably the allegation, 1, that he struck an officer with a handcuff while he was handcuffed. He used the handcuff as a weapon, striking an officer. And on 2 occasions, while struggling and resisting violently against law enforcement, he tried to reach and obtain the officer's firearm. It's of even greater concern, noting on 2 occasions he's been to state prison for violence against law enforcement. And on one of those times, he again attempted to deprive an officer of their weapon or communications device.
Okay.
Judge, speaking with Mr. Leith, first we're going to be requesting a photo order to basically photograph the numerous injuries he sustained as a result of his encounter with law enforcement. Judge, he's been residing in South Florida his whole life. Unfortunately, right now he told me he's not working. So financially, his resources are limited. He did say he's going to reach out to friends, but he doesn't know how much they can afford. So I'm going to ask you to take that into consideration, determine the
20 grand for that bullshit charge. Probable cause. They don't care about the aggravated battery. Deadly weapon.
I guess his concern, Judge, is the PC on count 1.
It sounds like more than a concern, based on the statements he just made. I do find probable cause as to count 1. I am going to impose a bond of $20,000. Counts 2 through 5, I'm imposing $1,500 on each of those counts. Count 6 is $1,000. Count 7 is $1,000. Count 8 is $100. Counts 9 through 9, 10, and 11, it's $5,000. $13 is $5,000. And if Mr. Leith posts his bonds, he'll be also on level 2 GPS. All right, good luck, sir. Pablo Padilla. I'll give this back to you, Madam Clerk, because this one has a PC attached.
Mr. Padilla is opposed to Judge. You see what I mean?
Mr. Padilla, you're before the court. Count 1, battery on a person 65 or older. Count 2 is resisting without violence, and count 3 is violation of misdemeanor probation. The bond attached to that is $20,000 on the misdemeanor probation. I do find probable cause, and I'll hear from the parties as to bond.
Your Honor, based on the level of violence alleged against Mr. Padilla's grandmother, I'm requesting a $10,000 bond, no victim contact.
Judge, I'm going to be requesting a $3,000 bond on Mr. Padilla's behalf right now. He told me he's working. He works for Bell South, where he makes about $15 an hour. But unfortunately, because of, as you see on 3, that $20,000, he just doesn't have the resources to go ahead and post the type of bond that the state is asking for on 1. That's why I'm requesting a $3,000 bond on his behalf on count 1, Judge.
And I would add, as I'm sure the court saw in the probable cause affidavit, that the victim recanted her story to the police. So I don't know how far this is going to go.
Is apparently an independent witness also.
Yes, who was unwilling to complete an affidavit referencing the events that he supposedly observed.
Yeah, and that's for an issue for down the road. The question is safety of the community and future appearance right now. And
I understand that.
And excuse me, and strength of the evidence, yes, the victim recanted after she originally said that he pushed his grandmother down to the ground with force, but there is an individual witness that confirmed that.
I'm not making a probable cause argument. I think it's thin, but I think there's probable cause. What I am pointing out to the court is something that this court is very well entitled to take into consideration when setting bond, and that is that the victim recanted her story, and the witness refused to sign an affidavit.
And again,
I've seen everything. I've read the probable cause affidavit. I've seen those statements. I do find probable cause. I am going to impose a bond of $5,000, no victim contact until further order of the court, and Judge Levy placed a $20,000 bond on the violation of probation warrant, so I'll leave that in place. Good luck, sir. Danielle Johnson.
North Broward.
All right, Ms. Johnson, you're before the court for possession of cocaine, and count 2 is felony violation of probation. It's an out-of-state violation of probation. So I do find probable cause. As to count 1, your bond is $1,000, and count 2 is a no bond hold. Good luck, ma'am. Naomi Dykes.
Paul Ryan, Your Honor.
Thank you. All right, Ms. Dykes, count 1 is a violation of felony probation. Count 2 is possession of heroin, and count 3 is possession of cocaine. Count 1 is a no bond hold. You will be before your division judge tomorrow at 8:30. What?
I only had a VOP.
Right, so for the VOP, you'll be before your division judge tomorrow at 8:30. As to counts 2 and 3, I do find probable cause, and your bonds on those are $1,000 each.
Your Honor, Ms. Dykes is represented by Michael Gottlieb.
Okay.
I spoke with Mr. Gottlieb's office earlier this afternoon, and they will be there for you in court tomorrow morning, Naomi.
Okay.
Get this whole thing straightened out there. That's the place to get it straightened out, okay?
Okay.
Okay, good luck.
Thank you.
All right, Daryl Kohawaski Vega. He bonded.
So we don't have to worry about how to pronounce his name.
I know. Oh, at least I was hoping you would be there to tell me how to say it. Michael Brown,
He bonded as well, Judge.
okay.
No, I want NCIC and CIC too.
Wilkinson Judy. Judy.
Question, Judge.
Sir, you're before the court this afternoon for count 1 is DUI. Counts 2, 3, and 4 are traffic infractions, not for magistrate. I do find probable cause, and I'll hear from the parties as to bond.
Judge, nothing to add from the defense.
Okay?
I wasn't gonna.
All right, sir, your bond is $500. Good luck. Jose Gutierrez Riveron.
Judge.
Michelle.
All right, sir, you are before the court for DUI. I do find probable cause, and I'll hear from the parties as to bond.
Judge, our only request is going to be a phone order so he can have access to the contacts, his friend and family to put his bond.
Okay? Did you wish to be heard?
No, Judge.
$500, sir. Good luck. Dillian Jean.
Mr. Jean, come on up, please.
Check his NCIC.
Mr. Jean, you're before the court for DUI. I do find probable cause, and I'll hear from your attorney as to bond.
Judge, Mr. Jean informed me he's going to post bond.
All right?
Yes.
Okay. All right, your bond is $500, sir. Anthony Michael Hill.
Mr. Hill, come on up, please.
All right, Mr. Hill, you're before the court for count 1 is possession of controlled substance without prescription. Count 2 is possession of drug paraphernalia. Count 3 is, count 3 is failing to walk in the crosswalk. That's not for magistrate. Counts 4, 5, and 6 are out of county holds. It looks like Charlotte County. And the bonds attached to those which are not for magistrate. You have 3,500, 5,000, and 2,500. So I do find probable cause, and the bond on count 1 will also remain at $1,000.
Judge, I'm going to be asking the court on count 1 to consider an ROR. I believe he has other matters from Charlotte County. I believe the basis of the stop was Mr. Hill supposedly was jaywalking, and that's what led to his encounter with law enforcement. Based on the nature of the encounter, I'm going to be asking the court to consider an ROR on count 1.
All right.
Your Honor, I'd ask the court, considering it's a felony offense, I'd ask the court to keep him at bond in place. What's clear from the other charges is he doesn't go to court.
Well, do we know if Charlotte County is one of those counties that will come and get him or pick him up?
My understanding is if they want him, all they gotta do is file a transport order, just like any circuit judge in Broward, if they want someone that's in custody. Sign a transport order.
Well, usually that is already there. I don't have that, so I'm gonna leave the bond at $1,000. And if Charlotte wants him, if there's an issue, I'm sure somebody will come back to court with that. Jason Pinnell.
Here he is, Judge.
All right, Mr. Pennell, you're before the court for count one, possession of alprazolam, and count two is a felony violation of probation. That's a no bond hold, and you should be before your division felony judge tomorrow at 8:30. I do find probable cause, and the bond on count one is $1,000. Good luck, sir. William O'Halloran.
Mr. O'Halloran, come on up, please. Here he is, Judge.
Sir, you're before the court for count one, it's DUI. Count two is refusing to submit to DUI test. Count three is driving with a suspended or revoked license. And count four is failure to drive in a single lane, which is not for magistrate. I do find probable cause, and I'll hear as to bond.
Your Honor, do you have his driving record?
Do we have driving records, Madam Clerk? O'Halloran?
Yeah, the only reason I'm asking is so you can see what I'm going to make some references to is, what did you do? Go back to subject query. Go back to subject query. You don't have to go to there, just go there, to the left. Yeah.
This is his driving record?
Then
Okay.
they don't have the right driving record. I'll print you the
This has nothing on there.
I'll print the court a copy.
O'Halloran?
Yes. Because he has at least 3 prior DUIs, a permanent revocation in the state of Florida. Just need a minute now to get it back up. Just click on DHS. DHSMV. Yeah. Details. And print results. Well, once it comes out. Print results. There you go. 2 copies.
I don't know. How would this show with nothing on there? You have another?
We're printing it out right now, Judge. 2 copies. Actually, he's got 4 DUIs at least. Let's look at the permanent revocation. Seriously?
Yeah.
You gotta talk to someone like you about this. Oh, God. Your Honor, I don't know if you maybe want to move to the next defendant. It's gonna take me a minute now. We're having a computer issue. I'm gonna have to print it off from my computer's driving record.
All right. Well, why don't you tell me what the record is? Is there a reason why you won't? You can't just tell me what the record is?
Yeah, no, absolutely, yeah.
Okay.
So anyway, he's had at least 4. Could you go back? Thank you. He's had at least 4 DUIs because in 2014, his driving privileges were revoked permanently in the state of Florida for 4 more DUIs. In 2012, he had a felony DUI with the DWLS. He was convicted in 2014, 270 days county jail, 5 years probation. Your Honor, it is clear that Mr. O'Halloran is not going to stop driving because he continues to keep driving with a suspended license, whether it's temporarily or permanently revoked. He poses a danger to the community because he continues to get behind the wheel under the influence of alcohol and/or controlled substances. Your Honor, I'm going to be requesting a $20,000 bond on count 1 and a $5,000 bond on count 3. Pretrial release with a GPS monitor and TAD monitor. No driving, no alcohol, no intoxicants with random testing. probably was someone else's.
Okay.
Judge, in speaking with Mr. O'Halloran, unfortunately, he's financially indigent. He's homeless at this time. He was working. He was working at Walmart, where he was making about $11 an hour, but unfortunately, because of medical reasons, he's on a leave of absence. Financially, there's no one that he can contact to help post his monetary bond. Judge, my understanding is last time he had a DUI offense was back in 2012, and he was placed on probation. In my understanding, and speaking with Mr. O'Halloran, he successfully completed probation with no violations. Judge, right now there's nothing he can afford. He's asking to be released on pretrial release.
And I'm sorry, I would just also note the driving pattern in this case.
All right, I do find probable cause, and based on the allegations, I am going to impose a bond on count 1, $5,000, and count 2 will be $100, and count 3, $5,000. I'm also going to include Tad. No driving. The license is revoked anyway, so should not be driving. And that's going to be on.
She said that. It's still standard.
We have the Tad, so yes.
Still standard with the tab monitor. It's still standard.
All right.
No,
Okay.
you were asking.
Good luck, sir. David McLean. Mr. McLean, count 1, you're before the court for discharging firearm from a vehicle. And count 2 is introducing contraband into the detention facility. And that one. Okay, I do find probable cause as to both counts. I'll hear as to bond.
One moment, Judge. Your Honor, based on these allegations, I'm going to be requesting a $10,000 bond and a GPS monitor. I would note, at the time of this alleged incident, Mr. McLean is out on bond for a pending carrying concealed firearm before Judge Merrigan. And I'd also ask for a release condition that Mr. McLean is not to be in possession of any firearms during the pendency of this case.
Judge, Mr. McLean, right now he works at a car wash. He's 20 years old, been here his whole entire life. He lives with his parents, Lauderhill, where they rent. They do not own their apartment, Judge, and his father drives trucks for a living. That's who he's going to be reaching out to, his father and his sister, to see if they can help come up with the monetary bond to have him released. I'd ask you to take that into consideration, determine reasonable release conditions for Mr. McLean.
What is the date of the prior incident?
Posted bond Oh, you know, I'm sorry, Your Honor. One moment, Your Honor. I'm sorry. The offense was declined. I apologize, Your Honor. But, Your Honor, my concern, I'd also note, according to one of the witnesses, it states that if Mr. McClain knows the police are after him, he'll switch vehicles. Matter of fact, we argued on his Instagram account. He made reference to this, showing a video under the post playing police games.
I do find probable cause. I am going to impose a bond of $5,000 with level 2 GPS. No firearms, no possession of any firearms during the pendency of this matter or until further order of the court. All right, we have a few matters on our hearing docket. Did you? This is the one I printed out, but do you have, it doesn't, if it's the same, usually it's. Okay. All right, we have Veronica Roman.
All run.
All right. What is, Ms. Roman had a 227 was her last arrest.
Yes, Your Honor. This is a motion for release. Information was filed today. Charges burglary of a conveyance and DWLS. The attempt was merged into the burglary or criminal attempt solicitation, and the possession of burglary tools was dropped.
All right. So, Ms. Roman, you were brought before the court for a 30-day motion. The state has filed the charges, and so I am going to deny the motion for ROR. All right. Robert Sissel.
Conte.
All right, Mr. Sissel has been in since 2:25.
Yes, Judge, it's a motion to release. State has not filed an information.
Has not?
Has not.
All right. So, Mr. Sissel, the state has not formally filed the charges against you, so you are entitled to be ROR'd. I'm signing the motion, signing the order granting the ROR. Sir, it does not mean that the state cannot file the charges, so it is incumbent on you to make sure that you pay attention to your mail to see if the charges has been filed, and if it has, when you have to come to court.
Yes, ma'am, Your Honor. I have one question.
Yes.
I'm still on a bond. Judge Levy has worked out a deal with me to get my license back. I have one class left to take. I'm wondering if I'm still gonna be able to ROR on that. It's the only thing holding me now.
Well, the only thing that is before me today is that motion for ROR. So if you have something in front of Judge Levy, I guess you're gonna have to go before Judge Levy on that matter. Okay?
All right. Thank you, Your Honor.
All
have
right.
a nice day.
You too. Erica Lovesmith.
Yes, ma'am.
All right. All right. Ms. Lovesmith has been in since 2:25.
Yes, Judge. A motion to release. State has not filed any information at this time.
All right. All right. So, Ms. Lovesmith, you're brought before the court for a 30-day motion for release. The state has not filed the charges against you as of today's date, so I am granting the motion for release. And you need to make sure that you pay attention to your mail to see if they do decide to follow through with the charges and if you have to come back to court, okay?
Yes, Your Honor. Thank you, Your Honor.
All right, good luck.
Thank you.
Earl Mitchell. All right, Mr. Mitchell was arrested on March 27th. So we're here for a second look on his bond status.
And Mr. Mitchell has 3 pending cases in addition to this case. He's out on a possession of cocaine, a felony theft with a resisting without violence, and a pending misdemeanor theft.
Okay. All right, Mr. Mitchell, what's the total amount of bonds that he has?
I believe it's
know?
$1,000 on the possession of cocaine.
Okay.
Or do you mean those other cases?
Yes, the other cases, I mean.
I'd have to check.
Okay, no worries. Mr. Mitchell, I'm going to deny the motion at this time.
For which one?
This is for the possession of cocaine.
I thought it was here for the misdemeanor. It's a misdemeanor petty theft. It's a possession of cocaine and another possession of cocaine. And one of the possessions of cocaine I just picked up on the 20th.
I'd stop talking right now if I were you, Mr. Mitchell.
Oh, okay. All right.
He's scheduled to see Judge Diaz on Thursday morning for the theft.
Okay.
Misdemeanor theft.
All right, good luck, sir.
Good luck, Mr.
Stephen Premdas.
He's also in Paul Ryan, Your Honor,
Okay.
and his girlfriend is present on his behalf today.
Okay. All right.
Judge, I'm going to be asking the court to consider releasing Mr. Predmus on his own recognizance. He's been a resident of South Florida since 1988. He lives with his uncle. He's lived with his uncle for the last 8 months. He's a former paramedic, and for the last 9 years, he's had the same job as a mover. Obviously, he has ties to the community, as his girlfriend has come here to court on his behalf today. I know that there might be some a failure to appear or a capias in the past, but I would ask the court, since he's not able to post the bond that's currently set, which is $1,250, that the court consider releasing him on his own recognizance.
All right, I'd ask the court to take no action today. It's not some failures to appear. He's been arrested 7 times prior to this arrest for failing to appear in court. This would be 8 in Broward County alone.
Then I'd ask the court to consider a pretrial release for Mr. Predmus, since he is currently unable to post any kind of monetary bond.
Again, Your Honor, I'd ask the court to take no action. He has shown an inability to willfully come to court.
And he also had a failure to appear in 2002.
All right. The bond is $750. Do you have a driving record for Mr. Premdas? You have a driving record for Premdas? No?
I might be able to get Your Honor.
Okay. Ma'am, is there something you wanted to say?
It's here for his support. I didn't know about his records before. I've been with him 2 months, but he has changed, and he's a hard worker, and he's a good father. I mean, I'm trying to get him in the right place. I'm unaware of his situation now.
Okay.
I spoke with Mary Ann.
Yes.
I spoke with Mary Ann before court, Judge. She might be able to come up with some money to get him out, but it's not going to be a lot, and that's why I'm asking for pretrial release on this suspended license charge.
Are there other cases that he's in custody with bonds on?
In addition to this felony, when he was picked up in this felony, he had an outstanding capias for failure to appear on a misdemeanor DWLS. That's why his bond's $1,250. It's $750 on the felony, $500 on the capias that his judge said, Judge Gottlieb.
All right, I'm gonna deny the motion for pretrial.
And he's scheduled to see Judge Gottlieb Wednesday morning on the misdemeanor.
For his division judge on Wednesday, and if they want to resolve those cases there, the judge will do that on Wednesday. Okay?
Thank you, Judge.
All right, Brandy Bonsek.
No problem.
All right, Ms. Bonsek is before the court for a second look on her bond status.
Yeah, good afternoon, Your Honor.
Good afternoon, Ms. Bonsek. She was arrested on March 27th.
Yeah, so, Your Honor, here's Ms. Bonsek's recent history. She was arrested January 1st of this year on a capias for possession of substituted cathinones and prostitution. She,
Which I am no longer on drugs anymore, Your Honor.
She pled the case out, was released January 4th. She was then arrested January 9th on a new grand theft and a violation of probation on the possession of substituted cathinones that she had been placed on probation 5 days earlier. She pled that out and was released March 8th of this year and is now before the court for possession of cocaine, heroin, alprazolam, and paraphernalia, despite being told she is no longer using.
But was not in my purse, was in the
Brandy,
vehicle.
right.
Brandy,
Ms.
don't say anything about the case.
I'm sorry, but it was not
okay.
on me.
When I say don't say anything about the case, you know what that means? It means you should not say anything about the case.
All right, I'm gonna deny the ROR at this time. Rowan Elgart.
Michelle, could you look up any notes you have?
Bonded, I believe, Judge.
Never mind.
Oh, okay. All right, and then on the, so he bonded, or I guess I write no action. No action? Just throw it away? Okay. Adesh Prasad? No, Terrence Walker. Oh.
Santi, Your Honor.
Have a seat, Mr. Prasad.
All right, Terrence Walker was arrested on March 27th.
Yes.
Was
Your Honor,
Mr. Walker here last week?
He was. The state offered 10 days. Your Honor kept that offer in place. That's because this is his sixth arrest this year since February 6th, all for trespasses. He did not want the 10 days at the time.
I did want 10 days.
Or there was some...
offered me 5 days. It wasn't 10, it was 5.
Now he's been in 6.
Well, the offer was in 5 days because I had said the last time he was in, Judge Powell gave him 5 days. So the offer wasn't 5. The offer was 10. It's still the offer on the table if he wants it.
Yes.
I just don't know, you know, like, he was here last week. I don't remember what happened.
It wasn't 10, so it was 5.
Well, it's 10 now, Mr. Walker.
All right, so what is he, he's trespassing? Mr. Walker, you want to resolve your case today?
Yes, ma'am.
All right, I will do adjudication and time served.
Thank you, Judge.
Thank you.
Is that what you wish to do, sir?
Yes, ma'am.
I think last week you were, I don't know, probably giving us a hard time.
Yeah, I remember.
So.
I was sleepy. I was in the middle of my sleep. I was woken up out of my sleep, so I wasn't able to think straight.
I'm sorry to
Stay away
disturb
from
your sleep.
Stay away from this place, Mr. Walker.
Okay.
Otherwise, you're going to be back, and it won't be 10 days next time the state's offering you, I'm pretty sure. Okay?
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea, and your sentence is adjudication and time served.
Okay.
Good luck, sir.
May I ask you a question?
Yes?
Will I be released tonight?
If there's nothing else holding you in custody, that's up to the jail. Adesh Prasad?
He's approaching, Judge.
Oh, sorry. All right.
How you guys doing this afternoon?
Your Honor, Mr. Prasad is here in alerting and prowling. You raised the bond to $500. I did not have an offer at the time, and the court was not willing to make an offer at the time. I still do not. You may recall this involved allegations that he went to one person's home on the 100 block of Northeast 26th Street, was pulling on the doorknob. He was confronted by the homeowner. Then the homeowner saw him go to another home in the neighborhood. He kept telling law enforcement, oh, yeah, I left my watch here. I was doing lawn work, and I left my watch. He didn't have any lawn equipment, but what made me more curious is why he thought, you know, doing someone's lawn would result in his watch being in someone's home. He also, 9 days before this arrest, he pled out a battery, a 2017 battery, 2016 grand theft auto and theft. He violated probation, 31.5 months state prison. 2015 corruption by threat against public servant, battery, criminal mischief with the violation of probation, 31.5 months state prison. Your Honor, frankly, I still don't have an offer because I think this matter has to continue to be looked at for a possible upfile to an attempted burglary.
All right, I'm gonna deny the.
If I may?
Yes.
Before you, and it's still a second-degree misdemeanor.
It
It's
is.
a loitering and prowling, Judge, and I understand the court's concern. Certainly, we're not, at this time, I do understand the state doesn't have an offer, but he's still in custody and he can't bond out, Judge. We're gonna be asking for the court to consider releasing him on pretrial release so he can be supervised on this second-degree misdemeanor. He goes to Florida Career College. He's studying their HVAC program. My understanding he's set to graduate soon. Also, Judge, he does work in landscaping. But right now, there's no one that can post his bond, so that's why he's asking to be released on pretrial release.
And may I please say something?
Not about the facts, not about the facts.
No, it's not about the facts of the case, Your Honor. I'm trying to change my life around from the past, Your Honor. That's why I enrolled in school. That's why I'm trying my hardest to work. I don't have no family. I don't have nobody. I know my past doesn't look good, but if you can please give me a chance for a brighter future to try to get myself together, because what happened that day
Don't talk about the facts.
is just a misunderstanding.
Don't talk about the facts means don't talk about the facts.
Yes, sir. But Your Honor, if you could please give me a chance, please, because the more days I sit in jail, the more days I miss at school, and I'm gonna be a certified HVAC for heating and AC ventilation. So the more days I sit in here, the more days I miss school. And
all right. Does did you say Mr. he has another case pending?
No, he what I said, he just pled out a battery that he was capious on in February. It was picked up on in February on a capious. He just pled out a battery 9 days before this arrest.
And Mr. Prasad, how long have you been in school?
Since I just been released from prison since February 14th, I just enrolled around March 10th. Okay, and I've been in HVAC. I go to Florida Career College in Oakland Park in 441. I'm just trying to change my life around.
I believe the program is Monday through Friday.
It's Monday through Friday.
Yeah, I'm gonna deny the motion at this time. On his own words, he just got out and he just enrolled in school, and then he's before the court again. Maybe let's see what's going on, so that he can resolve his case in his division. All right, good luck, sir. Do we have anything else on the docket?
That's it, Judge.
All right.